Case of Jacob Hurley versus Teresa Wilkes Powell. This matter is before the court on the plaintiff's underlying motion to modify parenting time in custody. This hearing is being conducted via Zoom. President is Attorney Alexis Spencer representing the plaintiff, father Jacob Hurley. Mr. Hurley appears to be present with Ms. Spencer. In addition, Attorney Jason Kazmarek is present representing defendant mother Teresa Wilkes. Good morning, everyone.
Good morning, Your Honor.
Morning, Judge.
Parties have conferred this morning with the front of the court. It was provided the court the following recommendation. The court should back up a little, indicate that this court did enter an ex parte order on May 3rd, 2024, which suspended defendant mother's parenting time for allegedly failing to follow doctor's instructions relative to treating the burn wounds of the minor child. The recommendation this morning is that mother should have parenting time every Saturday, 10 a.m. to 7 p.m., commencing June 1st, 2024. It's obviously this coming Saturday. And further, defendant mother shall initiate phone calls to the minor child every Tuesday and Thursday at 6:30 p.m. The parties shall use app close to communicate with each other regarding the minor child. And the parties will appear back before this court to review parenting time on August 6, 2024 at 8:30 a.m. And the issues of custody and parenting time shall be referred to the front of the court for formal investigation and recommendation. The issue of legal custody and parenting time is reserved at this time. The expiry order of May 3rd, 2024 should be set aside. The minor child shall not be interviewed as part of the custody or parenting time recommendation. And neither party shall make any disparaging remarks about the other on social media or otherwise. That is a recommendation. Ms. Spencer, is this recommendation agreeable with your client this morning?
Yes, it is. Thank you, Your Honor.
Mr. Kazmarek, is this recommendation agreeable with your client this morning?
Temporarily, yes, it is.
Okay. The recommendation is that the issues of legal custody and parenting time is reserved. Ms. Spencer, of course, I see your motion is to modify legal custody, correct?
That is correct.
Currently, the parties shall share joint legal custody. Is that correct? And you're seeking sole legal custody?
Correct.
Just wanted to make sure I understood the recommendation of Ms. Patrick. Good morning, Ms. Patrick. Right, Ms. Spencer, Mr. Kazmarek, do either of you have voir dire your respective clients regarding this recommendation this morning?
No, thank you.
Thank
you. All right. The court will adopt the recommendation. Thank you, Ms. Patrick, for your assistance this morning. And we'll put this back in our docket August 6th, 2024 at 8:30 a.m. If there's nothing further, I'll conclude this hearing. We can zoom out and counsel will mail the copy of this order.
I did not think Mom was going to go over that.
Good morning, Patrice. How are you?
Morning, good.
Once again, this matter is before the court for the purpose of reviewing custody and parenting time. This hearing is being conducted via Zoom. President Attorney Teresa Wilkes representing herself this morning, and Attorney Alexis Stang is present representing the plaintiff, Father Jacob Hurley. Mr. Hurley is with Ms. Stang. The parties have conferred with Mr. Walker from the front of the court this morning, who has provided the court the following recommendation. The recommendation is that mother's parenting time should be modified. Shall have parenting time every Monday from 4 p.m. to 7 p.m. and every other Saturday and Sunday from 10 a.m. to 6 p.m. No overnights at this time. Weekend parenting time for mother shall commence August 17th and 18th, which is weekend following the coming weekend. Further, the parties shall appear back before this court to review custody parenting time on October 1st at 10 a.m. That is recommendation. Ms. Stang, is this recommendation agreed with your client this morning?
Yes, it is. Thank you, Your Honor.
Well, do you understand the recommendation?
Yes.
Do you have any objection to the court adopting this recommendation as an order?
No.
Do you have any questions?
No, I don't.
Okay, and Ms. Stang, Mr. Hurley has been providing all the transportation, is that correct?
No. Teresa has been transporting, I believe.
Okay, is that, I just want to make sure it was on the same page. So any prior orders will continue in full force and effect unless they've been changed by this order. Ms. Wilkes, you understand that?
Yes.
Hopefully we can move back to overnights when we come back for the review in October. And where's Aiden going to attend school this fall, Ms. Dang? Elementary? Okay,
Yes.
so he's all set and enrolled and so forth?
Yes.
Okay. And it's important, Ms. Wilkes, that you be involved in his education. Make sure that you are signed up as with the school, so you're aware of all activities, parent-teacher conferences, and so forth. Right. Anything further this morning, Ms. Stang?
No, thank you, Your Honor. That was all.
All right. The court just would note for the record, when we're last in court on May 28th, 2024, the court did refer the issue of custody and parenting time to the front of the court for a formal investigation recommendation. The court has received the report and recommendation from Catherine Scott at the front of the court dated August 5, 2024, which recommends joint legal physical with the father, mother's parenting time alternate weekends. And those we can further review that when we come back for this review in October. Right, with that, the court will adopt the recommendation of Mr. Walker. Thank you, Mr. Walker. And that will conclude this hearing. Everyone can zoom out, and we will see you in October, Ms. Wilkes. October 1st, 10 a.m. You'll receive a copy of this order. It'll be a Zoom hearing once again, okay?
Thank you.
For the record, this matter is before the court for the purpose of reviewing custody and parenting time. This hearing is being conducted via Zoom. Present is Attorney Alexis Stang, representing the plaintiff father, Jacob Hurley. Mr. Hurley is present. In addition, defendant mother, Teresa Wilkes, is also present. Good morning, everyone.
Good morning.
Since we're last in court, I trust everyone has received the front of the court recommendation regarding the custody and parenting time.
Yes.
Ms. Wilkes?
Yes.
Okay. Parties have met with Ms. Brower this morning. Ms. Brower is recommending that the court adopt that recommendation that the parties shall continue to share joint legal custody of the minor child parties with the defendant. The plaintiff father being awarded physical custody. Mother's parenting time shall be every other weekend, Fridays after school or 4 p.m. if no school, to Sunday at 6 p.m. commencing October 11th, 2024. Holidays, as agreed, if parties cannot agree upon holiday, the front of the court holiday schedule shall control. That is a recommendation. Ms. Wilkes, do you understand the recommendation?
Yes, I do.
Do you have any objection to the court adopting this recommendation?
No, I don't.
I'm sorry?
No.
I am sorry. No. Okay. Yeah, your answer was no. Is that correct?
Correct.
All right. Thank you. I just, Ms. Dang, this recommendation given to your client this morning.
Yes, it is, Your Honor. We did also just want to state on the record, for purposes of having that, our concerns regarding the outstanding bench warrant, and how that could affect the minor child if Ms. Wilkes were to be arrested while the minor child is in her care.
That's a good point. Why, Ms. Wilkes, why is her bench warrant out? Did you fail to appear for a front of the court review hearing?
I haven't paid the court, so I'll get that figured out actually this Friday coming up.
Well, you could just come in and talk with Rebecca Hicks, in front of the court attorney, get that bench warrant set aside.
Yeah, I'll do that today.
I mean, yeah, come down absolutely today.
Oh, yeah.
Come down and talk with her.
Mhm.
I don't know when this schedule is going to begin, but the court does not want you driving with the 9-year-old child in your vehicle and you get stopped for speeding and then they have to be arrested in the presence of your child. That'd be horrible.
I know, I totally understand.
So, I don't know if is your license suspended or is it?
Oh, no, I have my license.
Okay, so, Ms. Wilkes, until that bench warrant's taken care of, I don't want you transporting this child. So who's gonna do the transportation? Is Mr. Hurley willing to pick up and drop off till the bench warrant's been set aside? Ms. Dang?
I will go talk to someone today.
Your Honor, I believe for transportation, what are you guys doing for
She picks
transportation?
up and drop.
Okay,
drop off.
so yeah, she has been picking up and dropping off. I don't know if my client would be willing to do one of the ways for transportation. I'm not sure that he's willing to completely change transportation due to her outstanding bench warrant that she hasn't dealt with.
Right. I'll leave that between the parties, and Ms. Brower can simply add this order that the defendant shall not transport the minor child while the bench warrant remains outstanding. So Ms. Wilkes, unless Mr. Early is willing to help with transportation, you need to find a third party.
Oh, I got my mom do it for me.
Okay, so again, the court's can order that as long as this bench warrant's outstanding, you shall not transport the minor child. Understood?
Understood.
You don't need to deal with this. Just go in and take care of it. You don't, even if you don't have the money, at least talk to the front of the court what's going on.
Okay.
Make sure they got your current mailing address. Let them know about your income. If you need to file a motion to reduce support, do that. Just be proactive. The worst thing you do is ignore it. You don't want to spend the night in jail.
I know.
Again, no transporting of the minor child while that bench warrant is outstanding. We'll add that to the order, Ms. Stang, and hopefully that will address it.
Thank you.
All right. Ms. Wilkes, do you have any questions for the court?
No, I don't.
All right. All right, the court will adopt the recommendation. The court defines the agreement between the parents being the best interest of the minor child. The court will only adopt the recommendation and enter the order. A copy will be mailed to both parties. All right, that will conclude this hearing. You can all zoom out. Have the rest of the day. Win versus
Thank
you.
Steele. This matter is before the court. And the defendant files a motion regarding parenting time. This hearing is being conducted via Zoom. It appears that both parties are present. The plaintiff, Mother Dakota Goodwin, and defendant father Timothy Steele. Good morning, everyone.
Good morning.
Good morning, Mr. Walker.
Good morning, Your Honor.
The two of you have confirmed with Mr. Walker. This morning, for the front of the court, Mr. Walker has provided the court with a fine recommendation. The two of you shall share joint legal custody of your minor child. Both shall have sole physical custody. A father's parenting time shall be as follows. Very specific. Father shall have parenting time every other weekend, from Friday after school or 4 p.m. if no school to Sunday at 4 p.m., as well as every Tuesday after school or 4 p.m. if no school to Friday to school or 4 p.m. if no school. The parties shall share holidays as they can agree. If they cannot agree, then they'll follow the Monroe County Friends Court holiday schedule, in which will alternate holidays. Child support shall be paid by defendant father in the amount of $105 per month commencing June 1st, 2024. Uninsured medical expenses shall be shared equally between the parties. And further, mother shall claim the minor child as a dependent for tax purposes every year. That is a recommendation. Mr. Steele, do you understand the recommendation this morning?
Yes, Your Honor.
Do you have any objection to the court adopting the recommendation?
No, Your Honor.
Ms. Goodwin, do you understand the recommendation?
I did hear something about Tuesday. What was that?
Okay.
Your Honor, I believe you stated that it was going to be every Tuesday, but it is actually every Thursday,
Thursday.
after school at 4 p.m.
That's correct. The court misstated. The recommendation does say father shall have parenting time every other weekend from Friday after school at 4 p.m. if no school to Sunday at 4 p.m. and every Thursday. I'm sorry if I said Tuesday. And every Thursday after school at 4 p.m. If no school till Friday to school or 4 p.m. if no school.
Okay, yes, thank you.
So with that clarification, do you have any objection to the court adopting this recommendation?
No.
All right, Mr. Steele, Ms. Goodwin, can you both please raise your right hand to be sworn? Ms. Goodwin, can you please state your name and current address, mailing address for the record, please?
Dakota Goodwin.
Thank you. And Ms. Goodwin, the recommendation that the court has received from Mr. Walker, that I've read on the record, do you believe that agreement also of custody and parenting time to be in the best interest of your minor child?
Yes, I do.
At this point in time, things can change and things will change. Your daughter's only 5 and things will change, but we need to focus on what's best for her right now. Do you have any questions for the court, Ms. Goodwin?
No, sir.
Right. Mr. Steele, could you please state your name and address for the record, please? Mr.
Timothy
Steele, do you believe this recommendation is in the best interest of your minor child at this point in time?
I do, Your Honor.
Do you have any questions for the court?
No.
All right, the court finds an agreement between the parents being the best interest of minor child. The court will only adopt the agreement. The court would like to thank Mr. Walker for his assistance and applaud you, Ms. Goodwin and Mr. Steele, for reaching your own agreement. You know what's best for your daughter better than anyone in this world. You don't want to relegate these decisions to a stranger like the court. And there will be challenges in the future, but they can all be addressed through effective communication. There's enough challenges in life. Make it good for each other and your daughter, and she will thrive in life. All right, with that, the court will adopt the recommendation. You both know the copy of that. Good job. And that will conclude this hearing. You can both zoom out. Have the rest of the day.
Thank you, Your Honor.
Alessa versus Matthew Alessi. This matter is before the court on the defendant's motion to modify custody parenting time and child support. This hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the defendant petitioner, Father Matthew Alessi. Mr. Alessi is present. Is Christy Alessi present on audio?
She did not appear this morning, Your Honor. I did try to contact her via 2 different phone numbers. I left a message at one phone number. The second phone number was answered by someone who said that I had an incorrect number and that Christy wasn't there.
Okay. Mr. Alessi, when did you last have contact with Christy?
I want to say right first week of March, maybe right before I got the boys.
So you don't have any contact with her during exchanges?
Nope, not really.
All right.
Your Honor, this is, I believe, the third time Ms. Alessi has failed to appear for a scheduled motion, so it's not out of the ordinary.
Was the mailing of your notice of hearing and motion returned as being undeliverable, Ms. Nemec?
It was not, and it went to the home that was the marital home, which was the subject of our last motion, so we know it was the correct address.
Very well. The court would note this matter was scheduled for 10:30 a.m. It's now 11 a.m. The defendant has failed to appear. She's not contacted the court. The recommendation of Ms. LaPrade this morning is that father shall have a possession of Oscar and Odin. Mother shall have possession of Sophia. Both parties shall have reasonable little printing time for the children that are not in their respective possession. This court's understanding that the two boys have been residing with father for some time now. Is that correct?
That is correct, since March 1st.
Right. And both parents live in the same school district, so the children are not changing schools, correct?
That is correct.
All right, that's good. All right, it's also recommended that commencing April 1st, 2024, the plaintiff shall pay child support. And it looks like, good morning, Mr. Pratt. So you got two different amounts for the two different children, correct?
So Your Honor, it's got two different payers listed. So it starts with mom as the payer, mom's the plaintiff. When there's 3 children, she'll pay $239. Down in the notes, it says for 2 children, father will pay $367 base support, $50 medical support for a total of $417. And then when 1 child remains, mom would pay $455 base support, $13 medical for a total of $468. Just because Sophia is the middle child, she's with mom, so that's how the child support recommendation came out, Your Honor.
Thank you. And I didn't scroll down far enough, Mr. Pratt, but I do see that. And were you able to capture all that, Ms. Nemec? You don't have the court to repeat that.
No, Ms. LaPrade very kindly sent me the recommendation so I can see it, and I've explained it to Mr. Alessi. It is a little bit complicated, but I think we have it.
All right, Ms. Nemec, you're asking the court to adopt this recommendation, Mr. Pratt, this morning. Is that correct?
Yes.
Do you want to voir dire Mr. Alessi? Is it necessary?
I don't think it's necessary. Thank you, Your Honor.
Right, the court, I don't believe it's necessary for the court to voir dire or question Mr. Alessi. Since Ms. Alessi has failed to appear, the court will adopt the recommendation, and that will conclude this matter. You will prepare the 2 uniform child support orders. Is that correct?
Yes, Your Honor.
Wonderful. Thank you. If there's nothing further, I will conclude this hearing. Good luck, Mr. Alessi. Thank you, Ms. Nemec and Mr.
Thank
Pratt.
you, Your Honor.
You're welcome.
Okay, Matt, you can go ahead and log
Good
off.
morning, Ms. Hicks.
Good morning, Your Honor.
Sir, are you George Ray III?
Yes, sir.
All right, court will call the case of April Atkinson versus George Ray III. For the record, Mr. Ray is appearing this morning via Zoom from the Monroe County Jail. Also present is Monroe County Front Attorney Rebecca Hicks. Ms. Hicks, can you provide the court some background information regarding Mr. Ray?
Certainly, Your Honor.
This is an arrears only case at this time. The current balance is $54,015.58. The last payment was received January 8th of this year from income withholding. There is a previous finding of contempt. It's from August 10th of 2015. It is a first finding and there is a 15-day balance.
Has Mr. Ray been charged with felony non-support by the Attorney General's office?
No, Your Honor, I couldn't find any history of that. It appears as if these arrears are too old for them to move forward with something like that now and occurred at a time when they weren't really, I guess, maybe pursuing them the way that they are now.
All right, thank you. Mr. Ray, can you please state your name and current address for the record, please?
George William, my sister's
Here's
home.
your last, it appears, according to the court file, your address is on. You have an obligation to keep the front of the court informed of any change of address, Mr. Ray.
Oh, at the time that I came up in January, I was still there. And then when I called, I called her again to inform her that I was laid off from my job, but I did not tell her that I had moved yet. That is my fault.
Well, it's not a matter of calling someone. You need to come in and sign a form.
Okay.
So, Mr. Ray, are you currently employed?
I started Piston Automotive on Alexis Road through Advanced Group Services. And so far it's supposed to come Monday, or I mean, Tuesday, which was supposed to be today. And my sister called the Advanced Group and let them know where I was at.
Okay. How have you been supporting yourself?
My sister's been helping me, and I ride around and collect pop cans and stuff and things like that to try and get money up. But I was just waiting for employment. I haven't been able to find anything in Monroe so far because I am on a bike.
All right, Mr. Ray, in front of the court has a 4-page list of employers that are screaming for employees. I can do your job today. You're too picky, too choosy. Mr. Ray, the court will not accept a suggestion you can't find a job. There's a lot of jobs out there. So, Mr. Ray, you've got 15 days hanging over your head. The question is, how much can your sister help you in terms of posting the cash bond?
She's on a medical disability.
All right.
She can't really help.
Okay, Mr. Ray, got 15 days hanging over your head. Anything you want to say before the court imposes a sentence?
Nothing other than, bringing on myself. I mean, I am trying to find work and everything. I'm limited by a bike, and I do have skilled trade, but.
Well, Mr. Ray Jack's Lawn Service looking for people. Michigan Bar looking for a dishwasher. The front of the court has a 4-page list. You need to keep in contact with the front of the court. You can avoid bench warrants if you keep in contact with the front of the court and you show them that you are making efforts. But when you just disappear and then you don't change address, don't appear, that's when bench warrants issued. So the sentence of this court, Mr. Ray, orders her 15 days in Monroe County Jail. Is he entitled to a day credit, Ms. Hicks?
I'm not sure what his arrest date was.
Mr. Ray, when were you arrested?
Friday afternoon, last Friday.
Judge, we're showing 3 days credit.
All right, court will give you the credit for 3 days, Mr. Ray. 12 days to be served immediately, but you can be released to home for dinner if your sister can post a $1,000 cash bond.
Okay.
So reach out if you got that job lined up for her. She can come pay a $1,000 cash bond. It's going to go toward your rearages. It's going to benefit you. It's not going to go toward fines or costs, Mr. Ray. It's going to go 100% to your rearages. So $1,000, you can be released. Otherwise, you can serve the next 12 days in jail. If I were to give you a date to appear before Ms. Hicks, you got to come in after release and fill out a change of address form.
Okay.
Ms. Hicks, what do you suggest review date for Mr. Ray?
July 23rd at 8 a.m.
So, Mr. Ray, you are to appear before Ms. Hicks for review July 23rd at 8 a.m. If you don't appear that date, another bench warrant can issue for your arrest.
I understand.
And the next contempt will be punishable by up to 90 days rather than just 45 days.
I'll make sure that does not happen.
And when you're out of jail, you come over to the front of the court, You fill out a change of address form, and you also pick up a copy of the 4-page list. They update it every month. A list of opportunities, good paying jobs.
Yeah, I went to Jack's Lawn Service. They said I had to have a license. And same way with Knowles. But I will go to Michigan Bar and Grill, whatever.
All right.
Hopefully, Piston Automotive will still hire me.
All right, hopefully so. And again, pick up that job list. Anything further this morning, Ms. Hicks, on Mr. Ray?
Nothing further on this matter, Your Honor. I'll prepare that order and upload it to your queue.
Nothing further, Your Honor.
I'm going to get a copy of this order, Mr. Ray, before you leave jail. It's got the date in there, Ms. Hicks' Zoom ID number. But if not, you need to come in front of the court and get a copy of that, because presumably mail to your old address, so you come in and change your address.
Okay.
All right. If you have any other questions, Mr. Ray, you can step out.
No more. Thank you much.
Echoing this sound system. Are you Courtney Lott?
Yes.
All right, to Ms. Lott is appearing via Zoom from the Monroe County Jail this morning. Also present is Monroe County Friend Attorney Rebecca Hicks. Ms. Hicks, can you provide the court some information regarding Ms. Lott?
Certainly. This case has a current monthly support obligation of $64 per month. The current arrears balance is $777.28. The last voluntary payment by Ms. Lott, she was previously arrested and posted bond in January of this year. She posted a $500 cash bond in January of this year. We also received a lump sum payment just on May 2nd of this year as well. There is no previous finding of contempt at this time.
How much was paid in May, Ms. Hicks?
$268.
Ms. Lott, you're currently being held in jail on a resisting and opposing a felony charge. Is that correct?
Yes, because whenever they showed up and they told me they were arresting me, I had my 3 small children and I just was trying to make a phone call to get someone to get my kids, because my 2 kids have autism and my 2-year-old was also there. I don't get any support for any of the my kids. I have 4 of them that I have full custody of.
Have you been arraigned on that criminal charge yet?
I'm sorry, I couldn't hear you.
Have you been arraigned by the criminal court on the criminal charge yet?
I seen the court-appointed lawyer earlier, but they said I was not going to court till after 1, I believe.
All right, this afternoon.
1:15.
Okay. All right, Ms. Hicks, she's got the pending charge, not been arraigned yet. Are you currently employed, Ms. Lott?
No, I'm waiting on my children's SSI to go through. I just filed it last month.
How do you currently support yourself?
My father.
Okay. Can your father post a bond on your behalf?
Nope, he posted the last one. He said he won't do it again.
All right. All right, Ms. Hicks, you're requesting Ms. Lott failed to appear for a review hearing. Is that correct?
Yeah, Your Honor, she failed to appear. So after her bond was posted, we scheduled a new review hearing for March 12th. She failed to appear at that hearing. And it looks like the bench warrant was issued for her on April 5th.
All right. Hey, Ms. Lott, you could have avoided this if you would have simply paid attention and appeared. You could appear by Zoom from your home.
I never got anything in the mail, and I had my phone broke that has the Michigan login website, so I don't even have that because they won't let me re-enter it because I do not have the phone number or the email I made the account with.
What is your current?
I have been in contact. My daughter has actually reached out and contacted me, and I tried to be able to get it through that, and this is what this all happened with. I was trying to go and actually press charges. That's why someone even got called to my house, was because they got wind that I was going to Adrian to file these charges.
Ms. Lott, what is your current mailing address?
111. I did there for 6-7 years.
Ms. Hicks, is that the address you have on file for Ms. Lott?
Yes, it is, Your Honor.
All right, so Ms. Lott, a copy of that notice to appear would be mailed to address. In addition, when you were last in jail back in January, you would have a copy would have been emailed over to the jail, and you would have had a copy when you were released from jail.
I never received anything by mail.
And you were told that on the open record when the court said you could release a $500 bond in January. You were given that date. So you could have, you should have, if you
No, I was
forgot it.
not.
and
Whenever
you
I
did get a piece
posted,
of
they did
paper,
not
which
give
I
me any
doubt that,
paperwork.
you
Your-
could have made
Your Honor?
inquiry at the front of the court, Ms. Lott, and you didn't do any of that.
Your Honor, for clarification, she never appeared in front of the court. She posted bond before being arraigned. So she was arrested on her bench warrant and simply posted the cash bond and was released. We did the order forfeiting the bond and setting that date, and it was mailed to the address that she just provided now on the record.
Okay. What action are you asking the court to take or suggesting the court take this morning, Ms. Hicks?
Your Honor, due to the fact that we did just receive that payment of $268 and that she is facing some sort of criminal charge, the front of the court would not be opposed to releasing her today without moving forward with contempt proceedings and just doing a short adjournment requiring her to come over to the front of the court upon her release and at a minimum pick up the jobs list and apply to some jobs between now and when we come back to court.
Okay. What are you suggesting for the review date?
July 23rd at 8 a.m.
Can that be put in my paperwork so I don't forget?
Yes,
Yes,
a
sir.
copy will be sent over to the jail, copy mailed to you. There's
Thank
the
you.
address to look for it. And, right, Ms. Lott, the court's gonna follow Ms. Six's recommendation. The court's going to, we're gonna cancel the bench warrant, you'll be released on a personal bond. So,
Thank you.
When you see the criminal court, let them know you got a PR bond in this matter. Hopefully you can get a PR bond in that matter so you can get back to your children. You're ordered to
I
appear
really
for.
appreciate it. I'm so sorry, sir. I'm so sorry.
Pay attention, Madam Mr. Lott. You're obligated to pay child support. You're not paying. You gotta contact with the front of the court. When you get released from jail, whether it's this afternoon or tomorrow, Mr. Lott, come over to the front of the court, pick up a copy of the jobs list. It's a 4-page list that they update every month of the jobs available in Monroe County, and they're screened for employees. And also make attempts, follow up with those jobs lists and appear for Ms. Six on July 23rd, 8 a.m. If you don't appear that date, bench warrant's gonna issue.
Okay, thank you very much.
So you've got to secure a job, make some payments between now and July 23rd. Copies will also be sent over to the jail. Any questions?
No, sir.
Okay, you can step out.
Thank you.
Bench warrant has been canceled. Welcome. DS. This hearing is being conducted via Zoom. Here it appears that we have both parties present. Sir, you're Tony Wilson, is that correct?
Yes, sir.
Right, also present, Monroe County in front of the attorney Rebecca Hicks. Ms. Hicks asked that Mr. Wilson appear this morning, presumably for failing to pay child support. Ms. Hicks, can you provide the course of information about this case?
Certainly, Your Honor. This matter was elevated to the court's docket following a hearing with referee Wes McKee that was held on May 2nd. That hearing was heard following a previous hearing with the referee on February 22nd of this year. This case has a current monthly support obligation of $622 per month. There's a current arrears balance of $5,872.60. The respondent last made a $100 payment on April 29th of this year. There was no payments made since that last hearing on May 2nd with the referee, nor has he filed any motions to modify the support, nor provided any medical documentation stating he's physically unable to work at this time. So the front of the court is requesting a finding of contempt.
All right, Mr. Wilson, contempt is punishable by up to 45 days in jail. Since there's a real good chance of going to jail this week, the court's going to tell you have a right to an attorney. If you can't afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand that, Mr. Wilson?
Yes, sir.
Are you requesting court-appointed attorney?
Yes.
Right, I need to ask you a few questions.
Okay.
Are you currently, Mr. Wilson, your current address correct?
No. I live in the state of Ohio.
Okay, what's in that? Give me your mailing address.
Hang on just a second.
Okay, why don't you give me your cell number, Mr. Wilson?
What's that?
Because I'm gonna give me your cell number because the court-appointed attorney is going to call you on your cell phone. So give me a cell number.
Okay. It's 141.
Okay, when you come into the courthouse, you can provide the front of the court with in writing your new address. Are you currently employed, Mr. Wilson?
No, I'm not.
How do you support yourself?
I've been doing a few side jobs here and there, just enough to get by. I've
Okay.
lost my job. It's been terminated. I had a back injury. I couldn't return back to work. And
Do you own any property of any value? Bank accounts, automobiles?
no, I just have a Chevy truck, 2004. I had a new truck, but I lost it because I couldn't make the payments on it. It got repossessed.
All right, the court will grant your request for court-appointed attorney, Mr. Wilson. We're going to provide that attorney with your cell number. That attorney is going to call you.
Okay.
Ms. Six, you want Mr. Wilson here on Thursday or Friday of this week? Any preference with your schedule?
Can we do Friday, Your Honor? I'm not available
Right.
on Thursday this week.
Fine. Right, Mr. Wilson, the court's going to order you to personally appear. You need to come to Monroe County and appear in Judge Braunlich's courtroom on the fourth floor of the courthouse on Friday of this week. That's May 31st, 2024, 11:15 a.m.
11:15 a.m.
That's correct. And Mr. Wilson, the court's going to strongly suggest that you bring with you $1,000 cash to pay toward child support arrearages or bring a toothbrush. Because there's a really good chance you're going to go to jail that day, Mr. Wilson, unless you can pay significant payment. Do you have any questions?
Okay. Nope.
All right, we'll see if you fail to appear. Petrol will issue. Rest assured, you'll serve considerably more time in jail than if you appeared and cooperated. So this is where you reach out to family and friends, Mr. Wilson. Is any amount you pay is going to go toward your arrears. It's going to benefit you.
Right.
And if you're disabled, you need to provide the court with the documentation you're disabled.
Yes, I was going to see if I could file a continuancy for a couple of weeks to get that stuff in. I got to get some doctor documentation. I didn't know I could file to lower my child support at all. Like, I'm in the dark about all this. This is all new to me. I know nothing about it. I thought I have to pay exactly what the courts tell me to pay, whether I made money or not.
No, Mr. Wilson, you can always file a motion to reduce your support. If you have no income, file a motion to reduce your support. You're sitting on your hands, and that's when things fester and become a real problem when you sit on your hands. You've done nothing to pay support. You could have reached out front of the court saying, what can I do? What can I do? We're here to help you, but you've done nothing. So the courts, when you come here on May 31st, hopefully you will have that $1,000. And also you can file a motion at that time to reduce your support.
Okay, I didn't know that.
A long way to give you continuance. Well, you got to ask questions, Mr. Wilson. In any event, do you have any questions?
No,
Okay.
I'll
So
do what I can.
all right, so we'll see you May 31st, 11:15, Bronx courtroom, fourth floor of the courthouse.
Thank you.
Ms. Jones, do you have any questions? You can appear if you wish by Zoom. You don't have to. It's totally up to you if you want to appear for your information.
Okay, you said by Zoom?
Yes, you can appear via Zoom just like you are right now, but Mr. Wilson can appear personally.
Okay, so will I receive a Zoom number? Because today we had an issue with that. I actually showed up at the courthouse because there was no Zoom meeting number, and then we figured all that out while I was there.
Okay, do you have a piece of paper and a pen?
I do. Give me just one.
Okay.
Oh, okay, it's the same one that we just joined on.
Correct.
Oh, okay, perfect. Thank you so much, Your Honor.
Welcome. You're welcome. Ms. Hicks, anything further this morning?
Nothing further, Your Honor. I'm preparing that order and I'll have it uploaded to your queue.
All right, so Mr. Wilson, you'll probably hear from the attorney there tomorrow or Thursday in advance of your court appearance on Friday, okay?
Okay.
Wilson? Yes, sir. Mr. Wilson, can you update the court with your address? Or did you go out in front of the court and fill out a form changing your address, or updating the court with your address?
I don't think we did the address yet.
You've got to do that in writing. We have an address of Western Avenue in Monroe. You're no longer there.
That's
Okay.
my sister's house.
Okay, you need to go down in front of the court, before you leave the building today and fill out a change of address form at the front window. Right. For the record, Mr. Wilson is present as briefly ordered by this court for possible contempt proceedings. Mr. Wilson was granted a court-appointed attorney present for the Zoom hearing this morning. Mr. Wilson is present personally, but present on Zoom this morning is court-appointed attorney Timothy Leiter, as well as Monroe County Family Court attorney Rebecca Hicks, and appears also we have the plaintiff Stephanie Jones present. Good morning, everyone.
Your Honor, good morning.
Good morning.
Ms. Hicks, did your office receive any payment from Mr. Wilson this morning?
Excuse me. Yes, Your Honor. He paid part yesterday and part today for a total of $1,000.
So that can be applied toward the arrearages. In light of that payment, first of all, Mr. Leiter, have you had a chance to talk about these proceedings with Mr. Wilson?
Your Honor, I have. I had a chance to talk to Ms. Hicks, and Ms. Hicks advised of a possible resolution to this contingent upon his payment of $1,000 bond fee. He has done that, and I've advised my client of that resolution. Ms. Hicks, I'd let you put that on the record.
Your Honor, in light of Mr. Wilson paying the $1,000, the friend of the court is looking for just an admission of contempt, but we are not asking for any immediate jail time. We would reserve any future potential jail as we monitor his case moving forward. I would look to do an adjournment out a couple of months to July 23rd at 10 a.m. so we can monitor that payments are made moving forward, as this case has a current monthly obligation of $622 a month.
Thank you. All right, Mr. Wilson, first of all, are you satisfied you received your right to legal counsel by conferring with Mr. Leiter?
Yes.
Ms. Hicks is recommending that if you admit to contempt this morning, the court find you contempt of court, but give you the key to the jail. In other words, you would not serve a day in jail unless you put yourself there by failing to appear for a future hearing or not taking a proactive role. If you can't pay the $622 a month, you need to file a motion to reduce your support. You just can't sit on your hands. Let these arrearages mount up. They're right now $5,800. It will be reduced by $1,000 with this payment. But you understand by admitting to contempt this morning, there'll be no hearing or testimony other than your own. Is that what you wish to do this morning? Is admit to contempt, Mr. Wilson, and not paying support out of available funds?
I didn't understand.
Correct. You wish to admit to contempt. All right. Raise your right hand to be sworn, please. Do you solemnly swear or affirm that the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God? Again, please state your name and address for the record.
Tony Wilson. Don't know my address.
Okay. You need to provide the front of the court in writing then on your way out.
Okay.
You have that with you. You got someone here in court with you. That person can give you the address. Okay. And if you move from that, you need to notify the front of the court in writing. Okay. Because if you're mailed a notice and you're not go there, it's your problem. It's a bench warrant issue when you don't appear for hearings. Mr. Wilson, do you admit and acknowledge you are obligated pursuant to order of this court to pay support for the support and maintenance of children born to you and Stephanie Jones? Yes. Do you admit and acknowledge you have outstanding child support arrearages about $5,800? Yes. Do you admit and acknowledge you've not been made any payments since April of what year was the last payment made? April of what year, Ms. Hicks?
He made a $100 payment, Your Honor, in April of this year. Prior to that, it had been several months.
Okay. Mr. Wilson, do you admit and acknowledge you've not paid the $622 per month as ordered by this court over the last couple months? Yes. You paid $100 in April of this year, correct? Yes. Did you pay anything for May? Okay. Have you been employed the last 3 or 4 months?
No, I've done a couple side jobs, enough to keep myself a little bit of gas and pay a couple bills.
Okay. Are you disabled?
I got a back injury and a lung disease.
Okay. Have you applied for Social Security disability?
Yes, we're in the process of that now.
Okay, you've already applied? Don't ask someone else. I'm asking you. You're the applicant. Have you filed a written application with Social Security for Social Security disability? You have doctor letters indicating that you are disabled?
No.
Okay.
Not yet.
So you're thinking of it, Mr. Wilson, but until then, you need to be proactive. If you don't have the income, I mean, first of all, I'm going to give you a 4-page list in front of the court of all the employers that are screened for employees. Page 3 of the court's docket, Isabella Turgato versus Jaden Knoll. This matter is before the court on the plaintiff's motion to modify child support. This hearing is being conducted via Zoom. President's Attorney John DQ, representing the plaintiff's mother, Isabella. Ms. Isabella is present with the DQ. In addition, defendant father Jaden Knoll is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
The parties have confirmed with Mr. Walker for the front of the court this afternoon, who has provided the court with fine recommendation that commencing June 1st, 2024, defendant Mr. Knoll shall pay child support in the amount of $534 per month based upon defendant father having 75 overnights. Uninsured medical expenses shall be shared as follows. The plaintiff mother paying 32%, defendant father paying 68% of uninsured expenses. That is the recommendation. Mr. DQ, is this recommendation agree with your client this afternoon?
It is, Your Honor.
Thank you. Mr. Knoll, do you understand the recommendation?
Yes, sir.
Do you have any objection to the court adopting this recommendation?
No, sir.
It is based upon their respective incomes. Mr. DQ, you'll prepare a uniform child support order?
I will, sir.
All right. All right. The court, thank Mr. Walker. The court will adopt the recommendation. Both parties having no objection. And Mr. DQ will prepare a uniform child support order. And that will conclude this hearing. Unless there's other questions, Mr. Knoll, I'll conclude this hearing. You can zoom out. Have a good rest of the day. Thank you, Mr. DQ.
Thank you, Your Honor.
Welcome. This is Amanda Branshaw. For the record, this matter is before the court for a review of the plaintiff father's parenting time. This hearing is being conducted via Zoom. President Attorney Amber Billmeyer, representing the plaintiff David Cho. Mr. Cho is present with Ms. Billmeyer. In addition, Attorney Christine Hills is present representing the defendant mother Amanda Branshaw. Ms. Branshaw is present, and Stephen Jednick, guardian ad litem, is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon.
The parties have conferred with Ms. Patrick, who has provided the court fine recommendation this afternoon that the minor child Cole shall undergo a psychological evaluation. Parenting time with minor child Braunlich will continue as previously ordered. Counseling, it's noted that counseling for minor child Braunlich and the plaintiff father has been scheduled. And lastly, the parties appear back for us court to review a parenting time for the two children and their dad on August 6, 2024 at 2:30 p.m. That is the recommendation. Ms. Billmeyer, is this recommendation agreeable with your client this afternoon?
Yes, Your Honor.
Thank you. Ms. Hills.
It is, Your Honor.
So counsel will communicate regarding choosing a mutually agreeable psychologist. Is that correct?
That's my expectation, yes.
Okay. So who's going to start? Ms. Billmeyer, you'll identify someone and propose that individual to Ms. Hills?
We had a brief discussion about, what needs to be done, but since the child's mostly with mother, I mean, my preference is to stay with Drescher's office, but, I guess we need some guidance there. It's not going to be my client's decision where he goes, so.
Obviously, we don't want to stall on this. Do you need to talk again in the breakout room and hopefully come up with, obviously, it's got to be someone that's will provide the service and take the parent's insurance.
I think among counsel, we can come up with someone. I don't want to speak for Mr. Jednick, but I believe his thought was to have sort of a fresh perspective from the psychologist as opposed to using the group that Cole's counseling with currently. So I know that all of us have worked with psychologists in the past, and I think it's a matter of us just putting our heads together and agreeing on someone. And I don't think there should be any issue with us doing that probably by the end of this week at the latest.
Okay, wonderful. That's what the court wanted to hear, Ms. Hill. So thank you. I, of course, confident you, Ms. Miller, and we'll communicate. And obviously, time is of the essence. We need to hopefully make some significant progress between now and August 6th so we can reestablish our relationship between Cole and his father. Mr. Jednick, is there anything you wanted to add?
No, I support the recommendation and everything else is in my report.
Very well, the court appreciates your assistance and efforts, Mr. Jednick. Ms. Billmeyer, Ms. Hills, do either of you want to voir dire your clients, respective clients, granting this recommendation this afternoon? Is it necessary?
I don't believe so, Your Honor.
No, Your Honor.
Okay. All right. We'll put this back on our docket August 6th at 2:30. Court will adopt the recommendation, copy mailed out to counsel. And now we'll conclude this here. Never can zoom out. Have a good rest of the day.
Thank you.
All right. Thank you, Your Honor. You too.
It's the middle of page 4 of this court's docket. Alyssa Chelsea Marion Johnson versus Timothy Westmoreland. This matters before the court on the plaintiff's motion for child support. Present for the Zoom hearing is Attorney Corey Shimmick, representing the plaintiff petitioner. Ms. Johnson, Ms. Stouter, are you Chelsea, Alyssa Chelsea Marion Johnson?
Yeah, Stouter's my maiden name.
Okay. All right. Is Timothy Westmoreland present on audio?
He is
Appears
not.
that, he is not present. This matter was scheduled for 3 o'clock, now 3:25. Ms. Patrick, have you been able to verify Mr. Westmoreland's address on the front of the court records to make sure we have valid service?
I don't believe we have an open file, but let me double check that, Your Honor.
It appears that the notice of hearing and motion was mailed by Mr. Shimmick to Mr. Westmoreland at 5.
That would be the legal address we have. That's the legal and mailing address the front of the court has, Your Honor.
Okay. Does Mr. Westmoreland currently exercise any parenting time, Mr. Shimmick?
He is, Your Honor, currently approximately every other weekend.
And does Miss Johnson, is that where the children are? Is that where the children spend time with their dad at that address in Taylor?
The one child, yes, that's where he goes.
All right, so
I believe
Mr.
Mr. Westmoreland picked up the paperwork from my lawyer's office, actually, by the way.
The initial paperwork, yes, but not the notice for this motion. We mailed him this notice.
And that was over a month ago. Did you try texting Mr. Johnson?
So,
I'm sorry, Mr. Westmoreland?
Mr. Westmoreland, yeah, I'm sorry, Your Honor. Mr. Westmoreland does not have his own phone. He lives with his grandmother and relies on her pretty much for everything. Miss Johnson tried to call his grandma, but she's fishing right now. She said she would try to get in touch with him, but we have not heard back.
All right, thank you. Well, the court, it appears that the court file does reflect proof of service of the notice of hearing with Zoom instructions were mailed to Mr. Westmoreland back on April 8th, 2024. He's not appeared. An effort was made this afternoon to contact him, and that was unsuccessful. The recommendation this afternoon, Mr. Shimmick, is that effective April 1st, 2024, that the defendant paid child support amount of $377 per month, based upon the defendant to father having 75 overnights. Uninsured medical expenses shall be shared by the plaintiff, mother paying 25%, defendant father paying 75%. That's the recommendation. Is this recommendation good with your client, Mr. Shimmick?
Yes, it is, Your Honor.
Well, the court will adopt the same. Thank you, Ms. Patrick. And if you can prepare a uniform child support order, Mr. Shimmick.
Yes, Your Honor.
All right. Is there anything further, Mr. Shimmick?
No, nothing further today.
All right. Thank you, Ms. Johnson. Thank you, Ms. Patrick. Court will adopt the recommendation.
Thank you. Have a great day.
Court's docket, Melissa Bennett versus Joseph Bennett. This matter is before the court on the plaintiff's motion for temporary orders. Plaintiff's motion for an ex parte order of exclusive use of marital home and defendant's responses. This present this afternoon is Attorney Kimberly Kuhn representing the plaintiff, Melissa Bennett. Ms. Bennett appears to be present with Ms. Kuhn. In addition, Attorney David Dart is present representing the defendant, Joseph Bennett, and Mr. Bennett is present. Good afternoon, everyone.
Good afternoon.
Good afternoon.
The parties have conferred with Mr. Pratt from the front of the court this afternoon. Mr. Pratt has received the following, has provided the court the following recommendation that the plaintiff shall continue to have exclusive use of marital home. All communication between parents shall be via text message. Neither party shall remove from marital home, shall remove or sell any marital property. Neither party shall have any person with whom they have a romantic interest in the presence of the minor child. Father shall have parenting time every weekend, Saturdays at 10 a.m. to 6 p.m. and Sunday 10 a.m. to 6 p.m. In addition, every Wednesday from 5 p.m. to 7:30 p.m. This on a temporary basis without prejudice. Parties shall have joint legal custody of the 11-year-old child of the parties. And with respect to child support, that the defendant shall pay child support in the amount of $545 per month, commencing April 1st, 2024. Uninsured medical expenses shall be shared by the parties as follows. The plaintiff mother paying 33%, defendant father paying 67%, based upon 75 overnights to defendant father. So it's on a temporary basis. That is a recommendation. Now, Ms. Kuhn, is this recommendation agreed with your client this afternoon?
Yes, Your Honor.
All right, Mr. Dart, is this recommendation agreed with your client this afternoon?
I believe I have objections and I also have inquiries. When I'm in
Yes.
order, I'll share those with the
You
court.
you do have objections. Your response, please. The court has read those objections.
Okay, I'm sorry. Shall I continue
Yes.
or? Oh, very good.
Yes, you may. You may
Just
respond,
with-
Mr. Dart. The
Thank
court has
you.
read all your objections.
With my objections stem from the parenting time schedule, and they also stem from the idea that he's now paying child support, but there is a one-sided status quo order requiring him to pay all marital bills. And I don't think that she should be able to what I call double dip. So I'm going to address parenting time first, if I may.
Okay, hold on. Was that discussed with Ms. LaPrade? Did you go through all the marital bills and who was paying what?
If the child support order is the only form of relief, then I probably don't object. But if it's, to be paying marital bills and child support, then I would certainly object. So I am a little confused. So that's kind of an inquiry.
Discussion, Mr. Dart, was there discussion in terms of what the marital bills are and how much they are each month?
There was some discussion, yes.
All right. Obviously, it needs to be taken into consideration. The court would agree.
Okay.
So do we need to go through all those marital bills right now?
It might be helpful to do that, or at least just say that. Go ahead.
Okay, what's the house payment?
It's $1,070 per month. Is that correct, Mr. Bennett?
Yes.
Okay, let's get the house on the market. Let's get the house on the market. If we can't afford it and it's an issue of who's going to pay it, let's get it listed.
Mr. Bennett, do you have any objection to that?
No.
Ms. Kuhn, any objection to listing the marital home for sale forthwith?
Well, right now, my client is in the process of looking for a job. So if the home gets listed and sold, she might not have a place to go with the child. So that would be the only objection. We wanted to wait and deal with that issue at mediation. We had talked about the payment of marital bills.
That's 2 months away. The mediation is 2 months away, Ms. Kuhn. We can't wait 2 months. If in fact, Ms. Bennett has no income, can't contribute, we need to, if we, let's go, we need to, you want to take some testimony? I mean, obviously it's not an unlimited source of money here. If in fact, Mr. Bennett's expected to pay all the bills, we should take that into consideration when setting a child support amount. Otherwise, we need to start liquidating these assets. Can't wait 2 months.
Well, right now she's having help from DHS to pay the monthly, some of the monthly utilities, and the mortgage is under the hardship program from June until August. So we do have some time.
I'm sorry, I'm not familiar with the hardship program.
It's to keep the home from going into foreclosure while we get the house prepared to be listed for sale.
Okay. Are you aware that Mr. Dart, this home was in this some sort of hardship program?
I'm sorry. The court asked if I was worried or was I aware? I didn't hear the first part of the question. I'm sorry.
Were you aware that this home was in some type of hardship program?
I don't believe I was, no. More importantly, I don't know that my client was, but he could be asked.
Okay, well, let's discuss this matter. I'm gonna put you back in the breakout room with Ms. LaPrade. Obviously, we don't have a full disclosure here.
Your Honor, it's my understanding that the house is going to be listed for sale, but it's just going to take some time. Ms. Bennett's working on trying to get a job so she can secure housing. So it's not a if, it's a when.
Okay.
But no, I was not aware of the program either, sir.
Okay, so no one's making mortgage payments right now, Ms. Kuhn, is that correct?
That's correct.
I had heard differently.
Status quo then. If we maintain the status quo, and if no one's making mortgage payment right now, there's no obligation, Mr. Bennett, to make a mortgage payment. Is that correct?
There is the status quo order says that he is to pay the status quo bills. It doesn't list them and it doesn't put any obligation on her. I was told that she paid the March and the April mortgage. Is that true?
The party's joint tax refund. She took that refund and she paid 2 months of the mortgage.
Is the May mortgage paid?
May is not paid.
I just need an understanding of what they're asking of my client in terms of status quo. That's why I objected. And now I'm saddled with a child support bill on top of it all, so.
Okay, well, I'm here for the first time. There's a hardship program. I don't know what that's about. Ms. Kuhn, you're saying there's no obligation to make a house payment till August?
They would like a partial payment or any kind of payment that can be made.
So they want some type of payment, a half payment, she's saying?
Yeah.
Well, let's move up mediation. Mr. LaPrade, is Mr. Walker available? Can we move mediation before July 25?
Your Honor, that was attorney schedules as well as my schedule. Mr. Walker's first available is not till July 11th either.
Okay. Well, Ms. Patrick is available. Let's get some other, do we need to move up this mediation here? And then if the parties don't want to make any payments, if it's a hardship program, then there's not an issue about the mortgage payment.
Mrs. Patrick is available on June 20th at 1:30, Your Honor.
June 20th, the council available June 20th?
I am.
I am.
And I'm sorry, is that what, 8:30?
No, that would be at 1:30, Your Honor.
I am available that day.
Ms. Patrick has appeared. Ms. Patrick, are you available on the June 20th at 1:30?
I am, Your Honor.
All right, so who will mediate on the June 20th at 1:30? We have a 12-year marriage. Parties are separated. We got real property. Are there pension benefits, Ms. Kuhn, that need to be addressed? Mr. Dart?
Do you have a pension, Mr. Bennett? I have his
No.
DRVFIF. I'd have to look at it. I don't have that memorized. But I'll
No
ask
pension.
him.
No pension.
Does Ms. Bennett have a pension, Ms. Kuhn?
You don't have a pension? No.
Okay, so you got real property, personal property, our custody, parenting time, support. Is there significant unsecured debt? The credit card debt?
Yes.
For 16,000.
About 16,000.
And another credit card for 6,000.
And another credit card for 6,000. So yes.
I'm looking at more like in the neighborhood of 20,000. Just a quick glance at my client's DRVFIF, and I need something else too. I've been asking for the DRVFIF several times this month. Ms. Kuhn, will you stipulate to get me that with an agreeable time frame so I don't have to petition the court, please?
Yes, I will, Mr. Dart, and I appreciate that. And I explained to my client today the importance of getting that finished, and she's going to be meeting with my paralegal afterwards to get that to you.
Would it be reasonable to expect that by the end of next week?
Absolutely, yes.
Thank you.
You are welcome.
How much equity are we anticipating from the house? If I'm not getting too far afield here.
Don't know. Is your client going to be paying his girlfriend's engagement monthly ring cost, or is that going to be off too? Because I don't want him taking marital funds and paying the engagement ring. He stated he has a monthly payment, so I get that he's engaged to be married, but I would like something stating that he's not going to use marital monies to pay for his girlfriend, I'm sorry, his fiance, and any expenses related to their engagement ring or anything else.
I will advise my client to stipulate to any applicable offsets to make sure that comes out of his end of any settlement or obligations in this case.
Perfect.
Okay, Mr. Dart, how much is this monthly payment for this ring?
Sir, the court is asking a question that I don't have the answer to.
Mr. Bennett, well, Mr. Bennett, because I want Mr. Bennett to pay that payment toward the house payment.
I'm
This
not
is a marital.
paying.
This is a divorce action. The court does not want any dime paid to a third party. He can borrow that from his parents. He can suspend making those payments. Mr. Bennett, how much you pay in this ring?
I don't pay anything. It's just on my credit card.
I'm sorry, it's not on your credit card? You don't pay anything? You have no obligation to any jewelry store?
No, it's on my credit card, but I don't pay anything.
Who pays your credit card bill?
She's paying it.
All right. All right, the court's going to order that Mr. Bennett shall not pay any expenses to any third parties while this divorce action is pending. Mr. Bennett, it appears that you're making any payment on this credit card, the court will hold you in contempt of court. Any money you have should be paid toward these house payments. So we don't, to maintain the equity you have in it. Okay, what's Mr. Bennett's income? Does he get paid every week, every 2 weeks? Mr. Darby, let's go through this accounting here because I want him paying money toward these marital assets.
I get 600 a week. 600 a week for 40 hours.
That take home?
Yes.
How much in the, Mr. Dart, the court's hard pressed to understand why Mr. Bennett cannot make the mortgage payment.
He's got a
500 a week, and mortgage payment's 1,000 a month.
Well, she had work until 3 months ago and is looking for work and may very well find some. She has $1,200 per month.
Ms. Kuhn, your client's gonna pay utilities, correct?
Yes, Your Honor, and he's making about net pay $918 a week. I'm looking at what he's making. His gross income he put as $843 weekly, but it looks like he gets also double time, so he gets shift premiums as well. So it looks like he's bringing home net from $778 to $918, depending on what premium he gets, based on the DRVFIF and his pay stub that I'm looking at, two of them.
Well, we did provide that, and I'm a little hamstrung that, you know.
She's getting unemployment benefits of $310 a week, and she's taking care of the cell phone, and she's getting some.
But there was also some program she's getting money from the DHS that I have nothing on.
Correct.
What's the DHS?
What expenses do we have other than the mortgage and utilities?
Yeah, they're just
The credit card payment that is the equity loan for $581 a month. That has not been paid at all.
The equity line of credit?
Yes.
Okay, so there's an equity line of credit of $581. That might have to just wait until we sell the house.
Yeah, I
We'll wait,
understand that.
we'll wait till the house is sold, judge, and get the equity line of credit paid from proceeds.
What is she making DHS per month? I don't quite understand that.
So Department of Social Services, it's a program for people that are on assistance.
Right.
And what they're doing is they're helping her with the monthly utilities. So that helps him as well.
I have to wait until I get a shut off notice and then I take the bill to them and they help me pay the bill.
So you're also paying a portion of it and they're helping. Okay.
So if we have a mediation then on June 20th, and if no one makes a whole mortgage payment, it's not gonna go into foreclosure, correct? Because of this forbearance program?
Correct, Judge. We're good until August.
All right, the court's gonna simply order that Mr. Bennett not pay any credit card expenses toward any third party until this divorce action has been completed. The court's gonna order that the parties mediate with Ms. Patrick. Thank you, Ms. Patrick. June 20th at 1:30 and subsequent appear before this court for continued pretrial conference. And the court's also going to order that the home be listed for sale. The court's not going to set a time frame, Ms. Kuhn, but I think both parties should contact realtors, get a fair market analysis, and so they can be prepared at mediation to discuss who they would suggest list the home. At least the parties can do some research in the meantime.
How would we word that order, Judge? I want to get the language that you're suggesting so I don't get this wrong. How home listed for sale, when or how, or?
That's the court's ordering that the marital home be listed for sale on the market. I'm simply not scheduling a time frame which that needs to be done, but I want them to be prepared at mediation to discuss with whom it's going to be listed. They each contact a separate realtor, have the realtor come look at the home, see what they do a fair market analysis. So everyone's got a piece of paper for market analysis with them when they prepare for mediation. The court's going to also order that Mr. Bennett not pay any debts toward any third parties, anything other than his family. So it's credit card. If he charged a ring for some third party, you better have the girlfriend paid for that, because it's not going to be coming out of his paycheck.
Is that all credit card debt or just that associated with the ring? I want to make sure.
Well, is it joint credit card debt?
It's not my debt. Is that what it meant? Is what it means?
Is it a joint credit card that you put the ring on?
Not in my name.
Okay.
So, sir, who is the credit card in that you bought a ring on? Mr. Bennett?
My
Whose name is that card in?
My name?
Okay. Is there any other debt on that card?
No.
How much debt is there for that ring?
1,700.
Okay.
Is there, Ms. Kuhn, is there any joint credit card debt that your client's aware of, or is it all in Mr. Bennett's name?
Is there any joint? Do both of you have names, or do you credit card debt in your name?
They just have a credit card in my name
Okay.
that we both used through the marriage.
So there's a credit card in her name that they used during the marriage, and then there's
And
credit cards in his name.
a Visa card in his name as well that we used through the marriage.
Okay,
Is around 2,000, I believe. Mine 6,000.
okay.
So
So
that would
it sounds like they were in separate names, but they were both used for marital purposes other than the ring. Did he actually put any money down on the ring, Mr. Dart?
Sir. Mr. Bennett, do you hear the question?
Yeah, they asked for $20. But I didn't pay
$20?
it. Yes,
Right.
but it
Right,
didn't come
the
out of my
person-
pocket. It didn't come out of my pocket. I
Okay,
can't
well,
afford anything.
All right, better not come out of your pocket between now and time we get divorced, Mr. Bennett.
I
So
can't
other than that, you
afford
can pay
anything,
other
sir.
credit card bills, Mr. Dart, just not anything toward this ring. Courts are offended that he even do that. Well, he's not even divorced. All right, so that can be discussed at mediation. The court will simply order that the home be listed for sale, and then the parties move in that direction. They can discuss it further in mediation. And in terms of the status quo order, Mr. Dart, I guess there's Ms. Bennett can, since she's got exclusive use, she can pay the utilities, and there's no obligation to pay the house payment at this point in time, but we don't want to delay this too long. So I'm not going to order that Mr. Bennett pay the house payment at this point in time.
I had objections to the parenting time I'd like to be heard on.
Okay, go ahead.
Okay.
First of all, where does Mr. Bennett reside and with whom?
Mr. Bennett, and he will testify to this. This is what he told me before. And sir, please pay attention because you'll be asked to affirm this under oath, I would anticipate. Mr. Bennett lives by himself. I've shown a picture of an acceptable residence that he lives in where the child would have a bedroom and would have her own bathroom. Up until February, when he was, and I think he would say, kind of kicked out of the residence, he was with the child every day. He was very familiar to her. He was part of her routine. He was all of that. There has been some dispute about whether or not he wanted to see the child since he left. I will tell the court that he had me file a motion in the first half of April to deal with parenting time issues. It took 6 weeks for that to get scheduled. So he was unable to secure parenting time in the first half of April when he petitioned this court. There was some concern that the child has autism. I don't see that pled in any complaints. I don't see any of the specifics of that set forth in any answers or anything of that nature. And I guess my fundamental objection is somehow the idea that my client is unfamiliar with how to care for that child when he had lived with her for 10 years. My client will co-parent. If there is communication between the parties, he will get every encouragement from me to participate in good faith in that. But what they're doing is they're kind of taking undue weight on the idea that he is not able to care for a child who has an autistic condition that he's been very familiar with and that somehow only mom is. And that's kind of what I take issue with. There's limited non-overnight parenting time that is insufficient. It is inconsistent with the lifetime routine that the child has observed. I had asked for equal parenting time, which I believe to be appropriate on an interim basis in this case. He has no fitness issues. He has no criminal history, no psychiatric history. He doesn't have any CPS history. He doesn't have any domestic violence history. So there's no reason why we should not continue what had been going on for years and years and years under the myth that somehow he doesn't know her condition and couldn't accommodate her weird, that's a weird word, the wrong word, her diet kind of peculiarities or things like that. He can accommodate all that, and mom should be ordered to communicate with him to start the process of co-parenting on that issue. So he is more than capable of overnight parenting time. And the idea that mom is the only one who can do that is not acceptable to us. We don't agree with that.
All right, thank you, Mr. Dart. We have a 9-year-old child. Ms. Kuhn, what's your client's objection to overnight parenting time?
Your Honor, this child is autistic. She has issues and problems with routines ever since Mr. Bennett left to be with his fiance, who also is a known drug addict and abuser. Ever since he left to be with his fiance, his parenting time has been sporadic to non-existent. He went the last 3 weeks without even seeing the child, claiming that his car broke down and that he didn't have a cell phone. So he has not been consistent. This child has a consistent routine. This child will absolutely lose her mind when the consistency isn't met. He has brought her home screaming and crying because he's only been able to keep her for a couple of hours before she triggers. So it's not like we have a child who's a typical child, Your Honor. We dealt with this extensively with Miss LaPrade, and Miss LaPrade recommended a schedule in the hopes that we can get some consistency going and we can expand on that schedule. Trust me, my client would love to have a break, but given the special needs of this child and given the lack of consistency that Mr. Bennett has exercised, presumably because he's with his girlfriend, we want to start slowly and at least work towards overnights and get this child to a point where she's not going to melt down. Court needs to look at the best interest of the child, not the best interests of Mr. Bennett or the best interests of Mrs. Bennett. This is about a child who has autism and who has issues and who melts down. So Ms. LaPrade heard all of this, Your Honor, and her parenting time recommendation is really geared towards moving forward. Hopefully Mr. Bennett can be consistent. Hopefully he won't cancel parenting time. Hopefully he won't call my client last minute saying, sorry, can't pick her up. Hopefully he won't bring her home early because she's having a meltdown. We want him to parent as well, Your Honor. So given the unique challenges in this case, not an issue of my client trying to punish Mr. Bennett. Like I said, this is about the child, and Ms. LaPrade looked at that. So I would ask that the court adopt the recommendation. We're coming back in June. Hopefully we can expand parenting time. We want to.
May I briefly rebut?
Yes, Mr. Dart.
Okay. The whole idea that these behavioral issues only occur in the limited time that father is permitted the child when he asks for parenting time, which is why he filed his motion in the first place, does not stand a whole lot of scrutiny here. The child has had behavioral issues, but not severe enough that she can't spend the entire day in school, not severe enough that she can't go to daycare, which she's gone to routinely. She doesn't at this point in time because mom has lost her job, but that may come up again. So I don't really see that the whole idea of like limiting father is going to be the problem. In fact, I would suggest that after mom's father out, perhaps these problems started getting a little worse because the routine that she had her entire life was upset. I think he has terrible problems, but if there were, he would call, try to work with mom. If he needed instructions and some cooperation, he would ask for it. He'll be getting all the encouragement in the world from me to do that. But to interrupt the longstanding parenting time is not warranted here. I think he would tell you that he tried to get time. The idea that he abandoned her for 3 weeks, he would take great issue with that. So
how many nights has a child slept in father's home since the party separated?
Mom won't permit it, and then she's using that as evidence of abandonment.
Okay, Mr. Dart, you sent the court a photograph this morning of the child in the bedroom. Wasn't that the bedroom at Mr. Bennett's home?
It is, but I don't believe that depicts the fact that doesn't represent that she spent an overnight there. It represents that she's capable of doing so and he has accommodations there. Mr. Bennett, is that correct?
Yes.
Okay, so the child's never spent a night at dad's home, correct?
Is that correct, sir?
Yes. Yes.
Okay. Okay, and what about the issue of consistency, Mr. Dart? Is Mr. Bennett, there's been times agreed upon and he's not followed through with that?
I don't believe that there was any agreed upon. I think it was a situation where mom was insisting on very limited times. So if there was a time when he missed it, it may have been like a problem with a car or something like that, but it was not an abandonment. And as I pointed out, nearly 7 weeks ago, I filed the motion that we're here on today because he couldn't get parenting time. So she's saying he wouldn't have time, but then she was denying it. He didn't want to take the child forcibly and cause an incident. He petitioned the court to bring this before the court, which took nearly 2 months to get heard, which happens, I understand, but it's not evidence of him abandoning the child.
Well, Mr. Dart's girlfriend, fiance lives in that home, correct? Mr.
Sir,
Mr. Bennett's?
I'm told not, but his testimony under oath is warranted at this point in time. I'm told not.
No, not at all.
Your Honor, he's violated the court order
May I
because
judge?
there was a court order to not have her there, and a couple of times he's taken the child to the home. The girlfriend has been there, even though he's well aware of.
Wait a minute.
that
If there's a
court
show
order.
cause,
So I know there's no show cause, but I'm just
But you're
bringing it
bringing
up.
this up sandbag
talking about
style.
it.
No, that's not appropriate.
In addition, Your Honor, Mr.
No.
Bennett was working 3 p.m. to 3 a.m. in the morning, so he wasn't doing bedtime routines or things like that. Like I said, my client is not opposed to expanding parenting time, and she has not denied him any parenting time. When he has contacted her to get the child, she has absolutely said, yes, take her. He'll only take her for like 3 hours at a time, and then he brings her back. So that's not a denial of parenting time. Like I said, Your Honor, this will be a good test to see if Mr. Bennett's going to exercise a parenting time. He is every weekend from 10 to 6 on Saturday and Sunday and every Wednesday. Hopefully we come back and he is exercising his parenting time and things are going well. This is not the end all. This is a temporary moving forward because he hasn't been consistent.
Very well. The party's going to mediate in 3 weeks. So at this point in time, the court's going to adopt the recommendation of Ms. LaPrade with respect to parenting time. Dad's parenting time will be every weekend. Saturday, 10 to 6, Sunday, 10 to 6, starting this coming weekend, which is June 1st. In addition, every Wednesday, 5 to 7:30. So that Wednesday will be, well, that's tomorrow, correct? So Dad's parenting time will be tomorrow. Is that correct, Ms. Kuhn? Mr. Dart?
Yes.
Okay, and who's going to pick up? Dad will pick up, Mom will pick up at the end?
I mean, he has transported her in the past, so yeah.
Yeah, I guess he's been transporting. We would ask that he feed her dinner during his parenting time, Your Honor. That's been an issue too.
Well, absolutely. This over dinner hour. So Mr.
Well, of course he will.
Bennett
I'm
tomorrow,
sorry.
5 to 7:30. Mr. Bennett should make sure the child is fed. Mr. Bennett will pick up at the beginning of his parenting time. Mom will pick up at the end. Is that, let's make sure we're on the same page here.
I mean,
Sure.
that's, yeah.
Yep, that's fine.
Mr. Dart, Mr. Bennett, would that work?
Yes, can I say something real quick?
I'm sorry?
Can I say something real quick?
Well, yeah, go ahead. You may want to talk to your attorney, but your parenting time will start tomorrow, 5 to 7:30. You'll pick up, and you pick up at Saturday, and you pick up at Sunday at 10 o'clock.
I've been on parenting time since day one.
Okay. Well, this hopefully this can be, it'll be consistent, and you'll be exercising this parenting time every time, and it can be discussed in more detail when you appear back. And yes, the court is, there's no reason why we shouldn't be able to expand to overnights when you come back on June 20th. If you have agreement or not, it seems we're definitely moving that direction, Mr. Bennett.
Okay, I appreciate that. Thank you.
Let's give it a try again. So the court's going to order that parenting time on a temporary basis without prejudice. Probably should have joint legal child support effective April 1st. Paid through the front of the court, $545 a month. The girlfriends, boyfriends shall not be present during that parenting time. In the presence of minor child, shall have exclusive of the home. Marital home shall be listed for sale. And hopefully we can reach an agreement on realtor when we come back on June 20th. All communication between parties shall be via text message, and neither party shall remove or sell any marital property. Mr. Bench should be encouraged to prepare a list of items he wants prescribed from the home so that it can be discussed thoroughly at mediation. And both parties should contact realtors, get a fair market analysis. The only additional thing the court's ordering is that Mr. Bennett not make any payments on any expenses for a third party, including but not limited to a ring. All right, anything further this afternoon, Ms. Kuhn or Mr. Dart?
Ms. Kuhn, will you prepare the order? If you give it to me, I'll review it promptly, and hopefully we don't have to 7-day it.
All right, Ms. LaPrade's going to actually adopt, I'm going to adopt the court, Ms. LaPrade's recommendation. That will serve as an order. If someone thinks we need a more formal order, then some council can prepare one. But I think this will cover everything between now and June 20th. We're just changing the mediation date from Ms. LaPrade to Ms. Patrick.
Correct.
June 20th at 1:30. And then the party shall appear before the court for continued pretrial conference immediately following that mediation.
We would just need a uniform child support order.
Yep, I can do that.
Thank you.
Mr. LaPrade, will you send, sorry.
Go ahead, Mr. Dart.
Mr. LaPrade, will you send me a copy of the recommendation?
Our office will send it as soon as it's signed, Mr. Dart.
Okay, anything further, Ms. Kuhn or Mr. Dart?
No, Your Honor, thank you.
No, nothing for me.
Right, you're welcome. Right, that'll conclude this matter. We can zoom out. And Mr. Bennett, make sure you are there timely tomorrow. for your parenting time?
I definitely will be.
5 o'clock every Wednesday and every Saturday and Sunday, 10 to 6.
Thank you very much.
Right, you can zoom
And
out.
I'll be in touch with
Thank
you
all.
shortly. Everybody have a good
Thank you,
day.
Mr. Pratt.
Thank you, Your Honor.
Bye.
This matter is before the court for continued pretrial conference subsequent to parties having engaged mediation with Ms. Patrick from the front of the court this afternoon. Present is Attorney Kimberly Kuhn representing the plaintiff, Melissa Bennett. Ms. Bennett appears to be present with Ms. Kuhn. In addition, defendant Joseph Bennett is also present representing himself. Good afternoon, everyone.
Good afternoon, Judge.
The court has been informed that the parties have reached their own agreement. Is that correct, Ms. Kuhn?
Correct, Your Honor.
Is that correct, Mr. Bennett?
Correct.
Okay.
Your Honor.
The court's going to have Ms. Kuhn state on the record what she understands to be your agreement. So listen carefully, make some notes if necessary, but listen carefully. After she does so, I'm going to turn to you and ask you whether or not it's an accurate statement of your agreement. Understood?
Yes.
And you understand that if the court adopts this agreement, it'll be binding. There'll be no trial or hearing. The court, you'll be bound by this agreement. Do you understand that, sir?
Yes.
Okay. All right, Ms. Kuhn, if you could please state on the record what you understand to be the parties' agreement.
Thank you, Your Honor. The agreement is as follows. Parties have one child, Ariana. Parties are going to share joint legal custody of Ariana, with the sole physical custody being awarded to my client. Child shall attend school and mother's school district. Parenting time is going to be reasonable and liberal. It's going to be per the agreement of the parties with the goal of moving to overnight parenting time for father. Vacations, holidays, and days of special meaning will be per the parties' agreement. For tax exemptions, my client is going to claim the minor child each and every year as a tax dependency exemption. However, off the record, if they create a different agreement, if for 1 year mom allows father to claim, that would be per their agreement, but in the judgment, it's going to state that my client will claim each year. Child support is going to be in accordance with the order that was entered by this court on May 28th, 2024. It commences on April 1st of 2024. Base support is $520. Ordinary medical is $25. Total is $545 a month. My client having 290 overnights. Defendant is getting a phantom amount of overnights at 75, but for purposes of support, we agreed on that. The father is going to be required to carry health insurance for the minor child so long as it doesn't exceed 6% of his gross income. It's provided through as a benefit of his employment. For uninsured medical expenses, my client's going to be responsible for 33% of uninsured medical expenses. Her husband's going to be responsible for 67%. Each is going to be responsible for carrying their own health insurance and paying their own medical bills. The marital home is going to be listed for sale. It's going to be listed for sale with a realtor by the name of Heaven Skaggs. Out of the net proceeds derived from the sale of the home, and that would include the payment of realtor fees, any mortgage payments. Out of the net proceeds, the following debts are going to be paid. A Capital One credit card, there is approximately $2,700 on that card. Approximately $6,129 on that account. There is a debt consolidation loan through Achieve in the approximate amount of $17,900. That is also going to be paid from the net proceeds. The minor child's medical bills that are outstanding, totaling approximately $13,000. If there's still money remaining after those debts are paid, then my client's third car loan, which is approximately $2,256 shall be paid. And then once that's paid, if there are still enough proceeds left, then husband's Capella Visa card with an approximate balance of $2,000 will be paid. If after all of those are paid, we still have proceeds left over, my client's going to be awarded 80% of those house proceeds, with husband being awarded 20%. There's a 2013 Ford Escape that's going to be awarded to my client. Husband is to sign over title to the vehicle within 3 days of the judgment of divorce being signed. I will include the VIN number in the event that that doesn't happen, so that wife can go to the Secretary of State to transfer that. My client is going to continue to have exclusive use of the home until it's sold and she moves out. Personal property, they're each going to be awarded all personal property in their own possession, with the exception that husband is awarded the barbecue grill. The generator will be awarded to my client. Retirement accounts are each going to be awarded their own retirement account, free and clear of any claims of the other. There's a joint Edward Jones account with $1.65 in it. My client's going to be awarded that account. We're just trying to clear up any joint accounts. If husband wants half of that $1.65, he's more than welcome to. Bank accounts, they're each going to be awarded their own individual accounts. There was a joint account at Fifth Third. Husband overdrafted that account. There's approximately $1,040 owed on for that overdraft. Husband's going to be responsible for 100% of any overdraft fees on that account. They're each awarded their own life insurance policies, free and clear of any claims of the other. Spousal support is forever barred as to both. Except as noted herein, each is going to be responsible for their own debts. There's a DBA for a cleaning company. It's going to be closed and neither party will use the DBA. Extracurricular activities, any agreed upon, will be, they'll each pay 50% of any agreed upon. They're each going to be responsible for their own attorney fees. My client is not seeking restoration of her maiden name. The only question I have is daycare costs. We did not discuss it. My client is proposing that they each pay 50% of all daycare costs and work related, and that husband would pay wife directly by the 15th of each month because there's no daycare in the child support calculation. So that would be the only question that I have, and that was something that was brought up while we were in the waiting room. And I know my client tried to get a hold of Joseph, but he probably wasn't able to click over because he's on Zoom. So that would be the only other question that I have for the work related. So Joe, are you in agreement that you would pay 50% of all work-related daycare costs and you would pay your wife by the 15th of each month?
Yes.
That would be the only other one. So that is the agreement, Your Honor.
I'm sorry, did you address pension benefits?
Yes, I did. They're each awarded their own retirement benefits, free and clear of any claims of the other. There was a joint Edward Jones account that wife is going to be awarded. It has $1.65 in it.
And with respect to the listed marital home, Ms. Bennett will initiate contact with the realtor and then inform her husband when the realtor is coming to present a proposed listing agreement.
Yeah, I'll put that each party shall cooperate with the realtor.
Okay. All right, Mr. Bennett, did Ms. Kuhn accurately state your agreement this afternoon?
Yes, she did.
All right, Mrs. Bennett, can you both please raise your right hand?
Yes, I am.
Yes, Your Honor.
Thank you. All right, Ms. Kuhn, if you want to begin with Ms. Bennett, please.
Yes, can you please state your full name for the record?
Melissa Dawn Bennett.
Melissa, you heard the agreement that I read onto the record, correct?
Correct.
Have you had enough time to think about the agreement?
Yes.
Do you have any questions of either myself or the court regarding any of the terms and conditions that comprise this agreement?
No.
You realize that had we gone to a hearing in this matter, that the result could have been better, worse, or the same?
Yes.
Notwithstanding that fact, you are waiving your right to have a full hearing on all these issues, and are you asking the court to adopt this agreement and make it an order of the court?
Yes.
Do you feel that this, all of the provisions that relate to Ariana are in the best interest of Ariana?
Yes.
And have you made a full disclosure of all of your assets and debts?
Yes.
And have you been a resident of Michigan for at least 180 days in Monroe County for at least 10 days immediately preceding the filing of the complaint for divorce?
Yes.
Were you and Joseph married on August 27, 2011 in Monroe, Michigan?
Yes.
And there was only one child born of the marriage, that being Ariana, who's age 11, correct?
Yes.
And are you pregnant?
No.
Has there been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage can be preserved?
Yes.
And are you asking the court to grant your complaint for divorce and also include all the terms and provisions that have been placed on the record?
Yes.
And you understand with spousal support has been forever barred. That means neither you nor your husband can ever petition the court for an award of spousal support.
Yes.
Are you also asking the court to waive the 6-month waiting period since this was actually filed in March? Do you believe that by waiving the 6-month statutory waiting period and allowing the judgment to enter, that that's going to be in the best interest of Ariana and give all of you finality?
Yes.
Okay. I don't have any other questions, Your Honor.
Thank you, Ms. Kuhn. Mr. Bennett, could you please, for the record, state your name and current mailing address?
Joseph Bennett.
All right, Mr. Bennett, did you hear the testimony this afternoon of your wife, Melissa?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Do you have any questions of Ms. Bennett?
No.
Do you have any questions of the court or Ms. Kuhn?
No.
Yeah, as you heard Ms. Kuhn note, there's a statutory 6-month waiting period in divorce cases in which there's a minor child. The purpose of that is to make sure there's no chance of reconciliation. The 6 months begins to run the date the complaint was filed. In this case, the divorce complaint was filed on March 28th. The 6 months expires September 28th. This court, however, does have the authority to waive the balance of that waiting period. And the court will do so if you both agree. Ms. Bennett is asking that the court waive the 6 month statutory waiting period and the judgment divorce within the next couple of weeks to simply move on. Are you, do you also concur with that request?
Yes.
Ms. Kuhn, do you have any questions, Mr. Bennett?
Mr. Bennett, have you made a full disclosure of all of your debts and assets in this matter?
I called Green Path. They got a lot of it for me.
So you made a full disclosure then for me?
I think
Everything
so.
that you know?
Yeah, Green Path did as best as they could.
Okay.
Ms. Kuhn, the court will waive the statutory 6 month waiting period to enter the judgment of divorce upon presentment. How do you intend to submit that to Mr. Bennett? Under the 7-day rule, or we submit that to him for his review and approval?
I can get his email address and I can send that to him. And I can also submit it under the 7-day. I'd like to make sure that I get it to him just in case there's any issue. And Mr. Bennett, there's going to be provisions in there that are statutory provisions. So the agreement that I read on the record is also going to have other boilerplate provisions that judgments of divorce have in them. If you have any questions, I don't represent you. I obviously represent Melissa, but if there are any concerns with anything, you can call me and you can ask me. But I just want you to understand that when you look at the judgment of divorce, there's going to be provisions in there that have to be in there. One of them, which is the Hague Treaty language, it's a convention that if it's not included in the judgment of divorce, the judgment of divorce will be rejected. So there will be boilerplate provisions in there. And I just want you to know that ahead of time, okay? And I'm not going to read them on the record because they automatically are included in the judgment. Does that make sense?
Okay.
But if you have a general question, like I said, I don't represent you and I can't represent opposing parties in a divorce action. I can answer a general question if you are wondering why something is in the judgment once I send it to you.
Okay, I appreciate that.
Can I get your email? Can I get your email address?
fm@gmail.com.
Thank you.
Ms. Kuhn, do you want to repeat that?
Yes, I am.
Actually, minus that one after Joe. I think it's just joe@gmail.com.
Okay. I am going to send you an email. If you don't get an email today from me, it's just going to be a test email. You're going to know that somehow that email wasn't a good email, and I'm going to want you to email me.
Okay.
This should be correct. It looks correct? Okay. Melissa's saying it looks correct. So I will send one and check your junk mail too. A lot of times, I don't know why, but we go to junk mail. So definitely check that. Okay.
Okay.
Okay. Thanks, Judge.
All right. Anything further than Mr. Bennett or Ms. Kuhn?
No, Your Honor. I will get the
No,
judgment.
Your Honor.
The court would like to thank you, Ms. Patrick, for her assistance, as well as Ms. Kuhn, and the court will applaud you, Mr. and Ms. Bennett, for reaching your own agreement. Without question, the best resolution is one in which you both participate and agree upon, rather than have this court decide matter at a trial. Based, however, on the testimony that's been presented this afternoon, as well as complaint filed in this matter, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the obvious matrimony has been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. According upon receipt of the judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from the bonds of matrimony. Good luck to both of you. Just one last suggestion, Mr. Bennett. The gas bill, other things awarded to you, retrieve those as soon as possible. And Ms. Bennett, contact the realtor. Let's get the house on the market as soon as possible. Get that listed. Of course, Mr. Bennett will have to sign the listing agreement. So set up a time where the realtor can come over and meet with both of you to review the comparable values around the area and suggest a list price that you're both agreeable with. If you can't reach agreement on the list price, then the court will make that decision. But with the advice of the realtor, the both of you should be able to come to your own agreement. Thank you again, Ms. Kuhn. That will conclude this matter.
Thank you, Judge.
Upon receipt of the judgment, the court will sign the judgment in order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from the bonds of matrimony. Right? Everyone can zoom out. Have a good rest of the day.
You too,
All right.
Judge. Thank you.
You too, Judge. Thank you.
Welcome.